Thank you. This is the minor guardianship docket. And I'm going to call number 7 on the docket. Who do we have present on this case?
Amanda Holder here representing the father in this matter.
Amy Powers representing the petitioner, Lily Grantham. Ms. Grantham is present in my office with me.
All right. And just remind me, Ms. Holder, you are representing which person?
This is father. This is Marco Perez.
So I will turn this over to Ms. Powers.
Thank you, Your Honor. We filed this petition for minor guardianship because the children had no parent willing or able to provide parenting functions for these children. The mother has historically always been the primary parent. She was arrested in July 2024 and remains incarcerated. It's our understanding that the father has had limited visitation since March 2024. A biggest concern is that these parents have 4 children together. There is 1 son, Nikolai, and 3 daughters. It came to the attention of the parties in March of 2024 that Nikolai and the oldest daughter had been having full contact.
Que Nicolai y la hija mayor habían tenido contacto sexual.
At that time period, the parents agreed that Nikolai would go reside with the father and the girls would reside with their mother. It is our understanding that Nikolai was at one point arrested as a result of the actions that occurred, and we believe that there is a criminal case pending, although we were unable to confirm that as he is a juvenile. From the time that Nikolai moved in with the father at the end of March, the girls' contact has been limited with their father to a few hours when the parents have met and switched the kids, meaning the mother took Nikolai and the father took the girls for a few hours. The biggest concern when the mother was arrested is that if the girls went with their father, they would be in the same household as Nikolai. Also of concern, the girls have disclosed that their father has hit the middle child in the head and calls her stupid. The middle child has delays. When we filed this guardianship action on August 14th, we requested an immediate order for emergency guardianship, placing the girls with my client. The court granted the immediate order, placing the girls with Ms. Grantham until today's hearing. Mr. Perez accepted service of the pleadings in this case on August 15th, including the immediate order changing custody to Ms. Grantham. On August 16th, my client allowed 2 of the girls to go to a birthday party at a long-term family friend, Sherry's home, for their 11-year-old cousin. The 3rd daughter joined Sherry's home on Saturday, the 17th, for the birthday party. The plan had been that Sherry would keep the girls and return them to my client Sunday morning. As stated earlier, Mr. Perez was aware of the orders and filings in this case as he accepted service on August 15th. Return of service has been filed with the court. Sherry was also aware of the guardianship action, and my client believed had been in support of it. On Sunday, August 18th, when the girls were supposed to be returned to my client, Sherry stopped responding, answering calls or text messages. Sherry did eventually communicate that she had turned all of the girls over to Mr. Perez. I became aware of this problem Monday morning when I came to the office. Mr. Perez was represented by an attorney in Lewis County, Mr. Ensley. Mr. Ensley represented Mr. Perez both in a parenting plan modification occurring in Lewis County and also in responding to a protection order matter in Cowlitz County. I spent Monday and Tuesday communicating with Mr. Ensley, trying to coordinate the return of the girls to my client. Ultimately, Mr. Perez refused to disclose where the girls were and refused to return them. We currently don't know where the girls are. We were unsuccessful in getting them returned. Ms. Grantham notified law enforcement in Yakima, Cowlitz County, Lewis County, the State Patrol, and also Grace Harbor County. Mr. Perez has a home in Yakima, and his parents have a home in Grace Harbor. It's our understanding Mr. Perez spends a lot of time at his parents' home in Grace Harbor. Law enforcement attempted to contact Mr. Perez at his home in Yakima, and no one was home. Police did make contact with Mr. Perez over the phone, but the girls were still not turned over. We are very concerned about the safety of these children. We're asking the court to extend the immediate emergency order and to appoint a guardian ad litem and set a review hearing in a few weeks. If the court extends the immediate order, I would ask the court to set a date specific by which Mr. Perez needs to return the children, or the court would ask the court to consider entering a bench warrant for his arrest. Ms. Holder just entered her notice of appearance. She filed a declaration written by the mother, but we have not received any responsive pleadings from the father. I understand the court may give Ms. Holder some leeway in responding today, but I would ask that this be set over so that he can file a response and we can have an opportunity to file a reply.
Ms. Holder?
Señora Holder.
Yes, Your Honor. The father is also very concerned about these children in this case. I agree a set over would be appropriate,
Yeah.
but my client would ask that the immediate emergency guardianship be dismissed. My client does believe that Lewis County may be the more appropriate venue for this matter, but he is willing to waive personal jurisdiction for the case, for the court to hear the case on the merits and be dismissed on the merits. Regarding why my client has not returned the girls to the petitioner in this case, the brother in this matter is no longer in father's home. He is staying with family friends a few hours away until more permanent arrangements can be made. Mother's declaration, which I'm sure the court has not had time to look at yet as it was filed yesterday, makes allegations that while she was a minor in her mother, the petitioner's home, he was subjected to sexual abuse by her father, her stepfather, her godfather, and a neighbor. The girls also report that petitioner's brother, known as Uncle Mike, visits the home frequently or lives in the home. And I'm unable to verify this yet, but my client's understanding is that Uncle Mike was recently released from incarceration for child pornography charges. The girls also report that Uncle Mike hugs them, makes them feel uncomfortable. And the father in this case could have filed for his own immediate protective order against Uncle Mike and the petitioner in this matter for allowing Uncle Mike to be around these girls. He didn't do this as he thought the fastest way to have this issue heard would be appear in court today. Furthermore, the petitions itself and the girls relate to father. That
Hacen
there-
relevo con el padre. I'm sorry, go ahead.
That there are a lot of adults living in grandmother's home. So many parents, so many adults, in fact, that one of the girls has to sleep in the garage with her grandmother, the petitioner. Father takes these allegations about Uncle Mike living in the home seriously. He called CPS to investigate, to initiate an investigation. Has been done.
Your Honor, at this point,
Y para ver si se ha hecho.
I'm going to object.
Okay.
Mr. Perez has not filed a response, and this is a lot of new allegations we have had no opportunity to respond to or hear prior to the hearing today.
Your Honor, if I may,
Go ahead.
Señorías, si me permite, proceda.
I agree with Ms. Powers. There is a lot of information here that she has not had the opportunity to respond to. The response I'm making now is to the allegations my client has not returned the girls and why that is. And those allegations about him not returning the girls are not in Ms. Powers' pleadings either. But if it would help, the court, I'll stop.
Stop. I'll give you a little bit more time, but keep it short. A statement and an affidavit could have been filed and provided to the court and to Ms. Powers.
Y a la señora Powers.
So I'll give you a little bit more, but that's it.
Ms. Powers alleges that, petitioner alleges in her petition, father has not performed parenting functions. My client disagrees with that. He has had constant contact with the children since at least 2020. He does not disagree that mother has been the primary parent. But he has been consistent in his visitation with the children.
Pero,
And in fact, in the petition for the immediate restraining order, which was ex parte, on page 2, paragraph number 2, there is a mention that there is a child custody case with father seeking custody, but material facts were not disclosed as to why my client was seeking custody. The safety and the health and welfare of these children should be paramount in this case. There are serious allegations on both sides here. I agree a set-over would absolutely be appropriate for my client to address the allegations that have been made in all the pleadings. But right now, having a set-over and having nothing done in this case for a few weeks until we can respond could put these children further at risk if either side's allegations are to be believed. And I would respectfully request from the court that while there is a set-over in process, we immediately get the court investigator, Ms. Schaefer, to look at some of these allegations to decide where the children should be or should not be until the rest of this case can be sorted out. And my client would be more than willing and be happy to find another place for the girls and for the son not in his care if the court and Ms. Schaefer determine that the children should not be in his home. He just asked that they also not be in petitioner's home.
Counsel, let's wrap this up. We're already on 45 minutes here.
Yes, Your
abogada,
Honor.
Ms.
vamos,
Powers?
señora Powers.
Very briefly, did the court receive our declaration we filed yesterday and provided a bench copy? I also emailed it to Ms. Holder this morning.
I did not. The last thing I have is from August 15th.
Okay, it included the information about the withholding of the children. I am not opposed to the court appointing the court investigator if they're able to do that. My understanding is that they're under Title 26, not under minor guardianships, but I think it makes a lot of sense if the court can appoint family court to do a quick turnaround in this case. The allegations are substantial on both sides. Nothing further, Your Honor.
Nada más, su señoría.
So I want it understood the dad had no right to ignore a court order. There is a process that could have been done that he failed to do.
Eh.
At this time, the court is going to extend the emergency minor guardianship. The father is to turn those children over by 7 p.m. tonight. If he fails to do so, the court will consider contempt, including fines and jail time, or direct violation of a court order.
Por,
In regard to appointing Jennifer, I will go ahead and do that. She is a court investigator. She is not a family law or family court investigator. Ms. Holder, I'm trying to understand, are you representing the mother too or not?
I
señora
am not
Holder.
representing mother, only father. I was unaware that mother's declaration was filed by my office. It was my understanding that that one of the family members had already filed that on behalf of mother. That family member has tried to work with Lewis County, where mother is incarcerated, so that mother may appear remotely in these proceedings.
I am going to go ahead and appoint an attorney for the mother. I'm not sure who that will be yet. I am also going to go ahead and appoint a guardian ad litem for Phoebe and is it Melinda? That will be Ann Height.
Esta persona será Ann Height.
And a court visitor for Anna. That will be Amy Turnbull.
Será Amy Turnbull.
And as I said, I will go ahead and appoint Jennifer, and I'm just going blank on her last name at the moment.
Schaefer, Your Honor.
Y también,
And I understand that cross is over, but I want the Ms. Height and Ms. Turnbull familiar with what's going on is the only reason I'm appointing all of them at one time. Meanwhile, I will go ahead and set this matter over 2 weeks so that everyone can get their filings made. Anything else for today?
¿algo más para el día de hoy?
Will the court be drafting orders, or would you like me to draft orders and send them over?
I would ask you to go ahead and draft those orders and get them to me for signature.
And I-
Obviously, have Ms. Holder sign off as well.
Y que la señora Holder también las firme.
Can I email them, or would you prefer them dropped off?
Drop off, please.
En
Okay.
persona, por favor.
And Your Honor, with having with having 2 guardian ad litem's appointed to this, how would the court look like for those guardian ad litem orders to look? I assume mother will be county pay. Would you like one order appointing a guardian ad litem, or 2 orders, one for each guardian ad litem? And how should those fees be divided
I
up?
got it. I got your questions. So Ann Height is a separate appointment. So that's one order. Amy Turnbull is a separate appointment, so a separate order.
Orden separada.
Jennifer Schaefer is a separate appointment, so a third order.
Una tercera orden.
The mothers will be county pay. The father will be private pay, 50-50.
50-50.
That's it.
Es todo.
Thank you.
Thank you, Your
Gracias.
Honor.
Gracias, señoría.
Amy Powers for the petitioner, Lily Grantham.
Go ahead for the mother. Angel Meisner.
Jennifer Schaefer, Family Court Investigator.
Amy Turnbull, court visitor.
Ann Height, guardian ad litem.
Anyone else?
I see Ms. Holder on the screen.
My apologies, I was having some technical issues.
Right. So where are we at this point? I wasn't quite sure.
So at this point, we had a hearing 2 weeks ago, and the court extended the immediate emergency order to today and appointed the court investigator to do a quick turnaround. Based on the timing that order came through in Odyssey, Ms. Schaefer didn't have adequate time. I would request at this point that we extend the immediate order 2 more weeks, set it over 2 weeks, and give Ms. Schaefer additional time to do more of a report.
Ms. Schaefer, I know that there was an issue in regard to that. And I think Ms. Turnbull had indicated, and maybe I'm confusing this with a different case, but Ms. Schaefer, will that work 2 more weeks?
Yes, 2 more weeks should give me adequate time to be able to reach out to all parties. I just wanted to do a brief report just to kind of update everybody where I was at this point in time.
Okay. All right. All right. And I did this differently than I typically would. I went ahead and appointed a court visitor and the guardian ad litem just because I thought it would be helpful to not have to miss out on some of the process that's going on. So that's why I did what I did. So anyhow, if you're wondering about that. So with that, anything further counsel from anyone?
Would the court like me just to send over another immediate order extending?
Yes, please.
Okay.
Not hearing anything, counsel?
Your Honor, I did want to bring up that the last hearing that we had a translator on, and I just wanted to inform the court and everybody that my client has now indicated he does not need a translator, so we will not need translation services going forward.
Okay. All right. Thank you. Okay.
And no objection, Your Honor, to this set over. My client does want the girls to be with the father, but we understand that Ms. Schaefer needs more time, reasonable time to do her investigation.
Okay. All right. And Ms. Turnbull, was this the case that you were saying you didn't receive an order either?
I think that was well, I think we all didn't receive it right away, but we should all have it now.
Okay. Okay. All right. All right. So with that, that's what we'll do is we'll go ahead and set this matter over 2 more weeks and then we'll go from there.
Your Honor, my apologies. I'm not available on the 19th. Could we set it over to the 26th?
Does that work for everyone?
I could have my report out by the 18th and the review for the 26th.
That works for me.
That works for me, Your Honor.
Yes,
No objection, Your Honor. That works for me.
Amy Powers here for the petitioner, Lily Grantham.
Amanda Holder here on behalf of Marco Perez, the father in the case.
Go ahead here on behalf of Angel Meisner, the mother in the case.
Amy Turnbull, court visitor on behalf of Anna.
Jennifer Schaefer, family court investigator.
And Ann Height, guardian ad litem for Phoebe and Maylinda.
Okay, thank you. Anyone else?
Lily Grantham is present in my office with me.
All right, thank you. All right, so with that, we have the 3 children that the guardianship is in regard to. Ms. Powers, I will turn this over to you at the moment.
Thank you, Your Honor. We're here today asking that the court extend the immediate emergency order of guardianship. Under RCW 11.130.255 subsection 1, appointment of an emergency guardian is appropriate when appointment is likely to prevent substantial harm to the minor's health, safety, or welfare, and no other person appears to have authority, ability, and willingness to act to prevent substantial harm to the minor's health, safety, or welfare. In this situation, we've got parents who have 4 children together. The parents separated in 2015. They divorced in 2017. The mother, Miss Meisner, has always been the primary parent since 2017. There were significant 191 factors found against Mr. Perez in the dissolution. The parents both indicate that he has worked through those and they're no longer concerned about it. But I think it's important that the court notes very significant 191 factors were made against him. Of greatest concern in this situation is that of the 4 kids, the oldest is a son, Nikolai, who has been having inappropriate relations with Anna. Nikolai has been a big focus of the court investigator report and also the pleadings in this case. What we've learned from the court investigator report is that Nikolai is living with the paternal grandparents at this point, so that is helpful. But I think there's still some major concerns. When you look at the declarations that were filed by both parents on August 21st, both parents' declarations say that the action that happened between the kids was consensual, not abusive. Anna is 12 years old. She turned 13 in May. She was 12 at the time that this all occurred. 12-year-olds do not have the ability to consent. It is highly concerning that neither parent recognizes this situation as a situation where abuse occurred. It was also concerning that initially the court investigator had trouble confirming where Nikolai is. I understand that Mr. Perez filed a declaration last minute this morning. I would ask for some leeway in order to respond to the allegations against my client that were made in his declaration, since we have not had an opportunity to reply. But namely, Mr. Perez indicates that my client, Miss Grantham, does not allow the children to speak Spanish at home. This is not true. Miss Grantham does let the kids speak Spanish, and in fact, the children have been teaching her Spanish. She is not trying to cut them off from their culture. The concern has been that Mr. Perez was trying to talk to the kids in Spanish over the telephone and has done some things that leave the kids compromised. The agreement was that he would not speak Spanish during the phone calls. What he has been doing is things like asking the kids how they are in English, the kids respond, and then the father follows up by asking how they are in Spanish. So he's going out of his way to try to violate that agreement that he wouldn't be speaking Spanish on the phone. But my client certainly is not disallowing Spanish between the girls. The focus is making sure that they stay safe. I'd remind the court that Mr. Perez took the kids against court order and kept them for several days. During that time period, he had Anna write and sign a declaration, which he filed with the court on August 21st. He's accused my client of having Anna sign documents and showing her court pleadings. My client denies this and says she has not shown Anna any pleadings. What Anna signed was a release of information so that Ms. Turnbull can access her medical and counseling records, which is absolutely appropriate for Anna to sign. At her age, she would have to give that consent. Since the girls have moved in with my client, we've also become aware that they have significant delays in their education. They've been signed up for school here. Melinda is testing at a 1st grade reading level, a 2nd grade math level, even though she's in the 6th grade. The girls have been disclosing physical abuse that they suffered in the home of their mother. They have also talked about being afraid of their father and having their father call them names, especially Melinda, and telling her that she's stupid. These are not small concerns. These are big safety concerns. The kids are finally in a place where they're registered for school. They're in counseling. They're getting medical treatment. We have a lot of eyes on this. Right now, there is a hearing scheduled for November 9th to review the guardian ad litem and court investigators report. My request is that the court enter an emergency minor guardianship order that is effective through November 9th, and then we can reassess at that point once we have input from Ms. Height and Ms. Turnbull. Thank you.
Ms. Holder?
Yes, Your Honor. I just want to touch on the review of the November 9th and extending the guardianship out to that. I believe the statute would require us to come back for at least one more hearing, or at least extend the guardianship out one more time prior to that hearing. So just on a procedural issue, I think that needs to take place. Regarding the submissions that we made, that my client made late, I do apologize for that. I wanted to make sure that the court is aware and informed, and all the parties are aware that Nikolai, the son in the matter, is enrolled in the school. There was some question about that previously, so that has been done. There was some question about him living with the grandparents. That has also been confirmed. The main reason that this guardianship, the emergency guardianship, was approved was because of concerns of Nikolai remaining in the home. That is no longer the issue. Further, mother had been the primary caregiver. That is true. Father did have contact with the children and was acting not as a primary parent, but was acting as a parent for the last 3 years. And he worked very hard at maintaining and reestablishing and maintaining contact with the children. So there's not an issue as to whether he is unwilling or unable to perform parenting functions. When it comes to the safety of the children, again, main concern was Nikolai being in the home. The girls, the allegations that my client has been physically or verbally abusive, that has not been confirmed. It has not been proven. It is on Ms. Grantham to prove that there is concerns about that behavior. As far as saying that the inappropriate activity between the two oldest children in this case is consensual, I don't believe either mom or dad used the word "it was consensual," they were doing it together. It is very clearly abusive. Those statements were made from the context of these children were doing this together, didn't know what they were doing. It is abuse, and that is why my client had no issue removing Nikolai from the home so that the girls would no longer have contact with him. As far as the allegations that Ms. Grantham is not allowing the children to speak Spanish, that the phone calls that have been going on, my client maintains that it's 1 or 2 words get spoken in Spanish. The understanding and the agreement was that he would try not to speak Spanish. He is proficient in English, fluent in Spanish. The girls are also fluent in Spanish and fluent in English. He wants to maintain their ability to speak Spanish, and it is nice to hear that Ms. Grantham is learning Spanish herself. But my client is not trying to violate any court orders or an agreement. As far as him not returning the girls originally, that was addressed at the original hearing. My client was under the understanding that from the girls, there was some concern about who was living in the home with grandmother, including questionable characters. Now that the court investigator has confirmed that that person does not have a criminal record and allegations against him were not confirmed, that is no longer an issue. As far as there being significant delays for the children regarding reading and math, the children, again, were primarily living with mother while those delays developed. My client, should he get the children returned to him during the pendency of the full guardianship petition, he plans to enroll the girls in public school at Barb's Elementary School and in Washington Middle School. He is not going to put the children back in the school that they were in, as it's very evident that there are some delays that were perhaps perpetuated by the previous school mother had them in. Now would be an appropriate time to put them in public school to switch schools, as they just got enrolled in one school. I know stability is an issue, but it's the very beginning of the school year. The girls haven't put down roots yet. It would be appropriate. Therefore, we ask that the emergency minor guardianship be dismissed, the girls be returned to my client, And if the court sees fit to continue the investigations with the GALs, which I also would see as appropriate, that the girls live with father during the pendency of the investigation. And the court investigator report did not make any recommendations. And because she did not make any recommendations, it can be assumed that there is not a serious enough issue that would keep these girls from being with their father. And so we would ask that the emergency minor guardianship be dismissed, pending a full investigation for the GALs to finish.
Oh, yeah.
Your Honor, I represent the mother in this case who is still currently incarcerated in Lewis County. We are fully in support of the father's position to have the girls. We support Ms. Holder's arguments and believe at this time that it would be appropriate for the father to have custody of the girls. We don't see any kind of safety threat, as mentioned by Ms. Holder. If there was some kind of threat or a serious concern, Ms. Schaefer's report would have provided us that information and those facts. Only thing that we can provide to the court is the fact that the father is able and willing to perform the parental functions. I don't see any reason why there is a need for an emergency guardianship. Everything that has been brought against the father has been either refuted or has been without any substantiated evidence against him. So it sounds like the son, which was the main concern, is proven that he is living with the grandparents and he's not even living in the same town as where the father is living. We are definitely in support of this motion for the termination of the guardianship and wish for the court to return the kids to father's care. Thank you.
Ms. Height, well, no, the court visitor, Ms. Turnbull, do you have anything on behalf of Anna?
Yes, I've spoken with Anna. Anna would like to have an attorney appointed for her.
Okay.
And Anna is in support of the guardianship. She would like to stay with her grandmother. She reports that that the declaration she made against her grandmother that was filed on October 21st was made in her father's home after being told lies by her father. She threw it away and her father pulled it out of the garbage, and she wants to retract that. She would like to stay with her grandmother. So I am in support currently of extending the minor guardianship until I complete my report.
Thank you. Ms. Schaefer?
Yes, Your Honor. The only concerns I really had was just what I put in my report, that even though I did read Dad's declaration this morning that came through my email, I just want to clarify that I did use a translator for speaking to Ms. Rodriguez, so I really don't think there was anything lost in translation there. I do kind of feel like I was misled that the child was enrolled in school before he was actually enrolled in school. And if the children do go back to Dad, he still does plan on seeing Grandma, where Nikolai is staying on a regular basis. And although he says they might be staying with his wife, you know, I do have concerns that they might still be interacting if that was the case.
Ms. Height, I know you're in the process of investigating, so I don't know if you have anything at this point.
Thank you, Your Honor. I do have, I think, a little bit of information that would be helpful for the court today. I've had contact with father, with grandmother by phone, and I visited with the older of these two children, Maylee, at her school. Two things that I think push me in the direction of saying I believe this guardianship, minor guardianship, should continue. Maylee was extremely clear that she does not want to leave her grandmother. She does not want to go back and live with her dad. She was very clear and appropriate with what she said. She wasn't angry or tattly. She was very factual and told me the reasons why, which will be in my report. Of concern for me is I had a conversation with father, and we were very patient with each other. There was no translator, but I feel like we had a very clear conversation. He made a statement twice to me that caused me concern. And as he was talking about how there have been times that they have, mother and father have exchanged the children so that mom could have a couple of hours with the older son and dad could have some time with the three girls. and they could maintain some kind of contact that way. As he described that, he said, I believe it is cruel for the children, meaning Nikolai and the girls, not to have time together. They love each other. They're brothers and sisters. And he used the word, I believe it would be cruel for them not to have time. We could make sure that they're not alone together. And he talked about understanding that there was a safety concern and that there needed to be some kind of supervision, but he did not seem alarmed about previous activities that had occurred. That's going to require some more investigation on my part, as nearly every part of this case is going. But it does concern me that he doesn't seem to understand the gravity of protecting the children. So I understand that's a sketchy and a verbal report for Your Honor this morning, and there's more to be done, but it does push me to recommend that this minor guardianship continue. I also, one last thing, Maylee she is doing well at school. She is behind, but she likes the school. She talked about a couple of friends she has. She's into a routine there. So I really believe, at least for the present time, it makes sense to leave her in this school. And I have not yet had a chance to visit Phoebe at school.
All right, so Ms. Holder, anything further?
No, Your Honor.
Mr. Goyak, anything further?
No, Your Honor, nothing. Thank you.
Ms. Powers, anything further?
Just briefly, in response to the parents' attitudes towards what happened between Nikolai and Anna, I would refer the court to the declarations and statement both parents filed pro se on August 21st. The father says Nikolai never abused the girls. They experimented together consensually. And the mother also says Nikolai did not abuse Anna and indicates it was consensual. So I am really concerned about the safety of the girls when both parents have that attitude.
So I did review the FOUS record. I am familiar with it. And overall, in regard to the current concerns of the court at this time, have to do with just what Ms. Powers is talking about. There is history here. There are issues that have been raised that are very serious issues about that could potentially end up harming the mental health or have already, is the lack of recognition and understanding of potential between children, in particular siblings. And the court is not, still feels at this time that that the health, safety, and welfare are at issue. And so the guardianship will continue for now. And, you know, I should say substantial harm, health, safety, and welfare. So as I said, the guardianship will continue for now. And I want to make sure that the father does speak in English during the phone conversations, again, for that, the purposes as indicated. And then we'll go ahead and take another look at this. Ms. Schaefer, I think at this point, we have things covered with Ms. Height, so I think we're good to end your obligation under this case. And then Ms. Powers, it was brought up in regard to the timing of the next hearing and that it would need to be set prior to the November 9th date. So I don't know what your thoughts are on that.
I think it depends on which way the court is granting a continuation of the, is the court granting a continuation of the immediate emergency order, or is the court willing to grant an emergency order, which can be in place up to 60 days? Our request is that the court grants an emergency and just sets it to November 9th. If we do an immediate order, I still think the court has the ability to set it out to November 9th, but I don't believe there's any timelines under the statute that allow it to go out for a long period of time, just that it needs to continue to be reviewed.
So at this point, the court is granting the emergency. Based on the files and record and the concerns for the safety of the children and the apparent lack of understanding of both parents, honestly, in regard to what Ms. Height had indicated. and the concern that without that recognition, that the health, safety, and welfare is at issue. So I also think at this point to move the children is if they're stable and in their school for now, the timing is not good. And I'd like to see that more thought out as we move forward if the children are going to return to the father. I also want the information or the attorney to representing Anna also on board is the other thing I'm looking at. So there are several things going on. There's a lot going on, bottom line. So I'll go ahead and grant that. And with that, I think the November 9th date is appropriate.
Thank you. I will circulate an order and then send it over to the court once all have signed off.
Okay. So
Sorry,
let me, one thing that I do want to get clarified, Ms. Holder, how often is your client, does he have any visitation at this time or what's going on there?
He is only having phone calls with the girls. I believe they're only phone calls. If you'll hold on for 1 second, we confirm to see if we're getting video calls as well. Just phone calls, no video calls.
Okay. All right.
Your Honor, if I might, we were speaking about the date of November 9th. I believe it's actually November 7th.
You're right.
November 9th is a Saturday.
So November 7th.
I apologize.
And sorry, Your Honor, was that to when the emergency order will expire, or is that the next court date?
That's the next court date.
Thank you.
Okay, so we'll set it to November 7th. We'll look forward to an attorney will be on board at that point for Anna. We'll have a report from hopefully from Ms. Hyde at that point. Ms. Turnbull, do you see any need for you to remain at this time?
Not necessarily. Would you like me to finish my report to submit that?
I think that would be fine if you feel comfortable with that. If not, then we can wait.
Whatever your preference is.
Okay, why don't you go ahead and just stay on and then if there are any questions in regard to your report.
Okay.
All right. With that, anything else today?
Yes, Your Honor. And since you brought up the issue of the visits, is there any way that we can set up supervised in-person visits as this emergency guardianship is going to extend out for another month and a half?
Ms. Powers?
Give me 1 second to just clarify with my client. My client would have no objection to professionally supervised visits. She doesn't feel comfortable supervising visits herself. I'm not sure if there's any other non-professionals available that the parties would be comfortable with.
Ms. Holder, any suggestions?
I would suggest that Ms. Powers and I can facilitate something off the docket, and we can work with possibly like Beth Fellows at Connecting Family and Cowlitz to set up at least some professionally supervised visits just to make sure that the girls are physically seeing their father.
My client would agree to reconnecting families.
Okay, so definitely I think that would be good for that contact to be made. Mr. Koyak, I'm assuming that Lewis County doesn't have any visitation abilities, but I didn't know.
I don't know the answer to that, Your Honor. I don't know how comfortable the girls are going to jail. I just don't have an answer for what my client wishes as far as visitations. Maybe you leave it open as a possibility as long as they're supervised.
Okay. So I think if you can come to an agreement between the parties about it, I'm fine with that. If not, just note it on and we can address the issue.
Thank you, Your Honor.
All right. All right. If there's nothing further, we'll see you on the 7th of November.
Thank you.
Thank you, Your Honor.
Who do I have on this matter?
Thank you, Your Honor.
Christine Dow representing the Guardian, Jamie West.
And respondent mother, Marley Melton.
Guardian ad litem, Amy Turnbull.
Okay. Where are things at with this at this time?
Your Honor, it looks like things are on track. The child has had his last scheduled counseling session. Ms. Melton attended the child's doctor appointment in August, and she has made an additional appointment for him in December to monitor his condition. We'll have to hear from Ms. Melton as to school registration, but it's my client's understanding that she has registered him for school. If he is registered for school, it looks like the court should be able to find that while the child is bonded to his grandmother, she's clearly able to care for him. He now has a parent who is both willing and able to take over his care. What we would ask the court to do today is to reissue the guardianship order one more time to accommodate the transition period that was recommended by the guardian ad litem in her report, such that the child transfers his residence to Ms. Melton, but for the next couple of months, he spends every other weekend from 5 or 6 p.m., depending on the party's work schedules, to 5 p.m. on Sundays with Ms. West. The first weekend with Ms. West in the rotation, we would ask be this weekend, since her letters of guardianship, at this point, they expire on the 26th. That gives them the weekend to make sure that the child has all of the final details addressed for transfer to his mother's home on Sunday night. We would also ask that the every other weekend schedule run through October. Ms. Turnbull recommended that occur and then taper off to one weekend a month by the end of the year. So we're asking that it run through October, then move to one weekend in November, one weekend in December. My client has asked if we could arrange for the child to be with her on the day of Christmas Eve, when her family celebrates together in Maple Valley, which makes it convenient for everybody if she then delivers the child to his mother so that he can go to bed in his mother's house on Christmas Eve and get up in his mother's house on Christmas morning. The GAL has also recommended that 2 reviews be scheduled at 3 months and at 6 months to ensure that Ms. Melton is able to manage the child's medical care and schooling, since those were the court's primary concern initially in this matter. There's one last recommendation that the guardian ad litem made that has not happened that my client would actually like to see happen. That recommendation was that there be meetings between Ms. West, Ms. Melton, and the child's counselor, Grace Reinecke. The purpose was to establish a pattern of useful communication between these two, make sure that there are no misunderstandings and that communication is able to continue for the child's benefit as we go forward. The recommendation was for 4 meetings. If anybody thinks that's excessive, my client would like to have at least 1. Just because there has not been a pattern of great communication between the two of them so far, and she would like to make sure that that gets addressed.
Okay. Let me hear from Ms. Melton, your thoughts on that plan?
So first of all, he is enrolled at Jefferson Elementary. His first day is September 4th. I'm absolutely okay with biweekly visits up until December. And for the Christmas Eve, that works for me too. That works for us. I want him to be able to spend Christmas Eve with Miss West and her family. As for the appointments with Miss Renke, I believe she is graduating now. So I'm not sure who else we would be able to go to for that, but I'd be all right with that as well.
Okay. Thank you. Ms. Turnbull?
I'm in support of everything that's been proposed this morning. I think they're doing great.
So I just want to compliment everybody that this is, a matter of working together for the best interests of a child. To me, this case represents what's supposed to happen in these cases. And I appreciate that. So with that, Ms. Dow, I'll just grant and approve what you've requested. It sounds appropriate, and it sounds like it would be a smooth transition without too abrupt. It kind of puts things where it needs to be. So if you want to go ahead and prepare an order to that effect, run it by guardian ad litem and Ms. Melton and get their signatures and then get it to me for signature. Now, do you want to review here in a short time, or?
Your Honor, I'll let Ms. Turnbull speak to that. It was her recommendation that there should be 2 reviews. And I My understanding is that it was mostly just to make sure that Ms. Melton is not running into any unexpected problems.
Ms. Turnbull?
Yeah, that was my recommendation. And I'll leave it up to your honor's discretion at this point.
Okay. So I think what we'll do is we'll go ahead and just set at least one for now. And then if we need another one, you can ask for it at the next hearing. But I think at this point, we'll go ahead and let's just have a review on a September 26th. And that will be at 10 a.m. that day. We're switching times on this docket, 10 a.m. And that way we can just make sure things are going smoothly and then go from there.
All right. Thank you, Your
All right.
Honor.
Thank you. Sounds good.
Thank you, Your Honor.
Thanks.
All right. So do we have the petitioner?
Your Honor, Christine Dow representing the petitioner, Jamie West, and Ms. West is also present.
Yes, I'm here.
All right. We have the mother, Marlene Melton. Do we have the father?
Father's deceased.
Oh, that's right. Sorry. And then we have the guardian ad litem, Amy Turnbull. All right. So still doing it. All right. I'm going to mute everyone until we need to. Let's see if that's what's causing it.
Your Honor, I believe it's Miss Melton's device that's causing it.
She's muted. Okay. She's muted, so it shouldn't be it. So we'll just try this and see if that works. Okay. So first off, where are we at with this? I'll ask Ms. Dow.
Your Honor, we have a transition order that may be one of the orders that you signed yesterday. There was a little delay getting it back to the court. Ms. Farr gave us some input on the order and we had a little confusion here about who was reviewing it, but it was delivered to your office on Monday. According to my client, things are going well. The letters expire tomorrow. My client commented to me that both she and Mother Marlene Melton have been communicating much better. It looks like they've been able to set aside whatever differences they may have had and work for the benefit of this child. So this appears to have been a successful transition so far. And I believe that we don't need any more reviews, that we can allow this to be completed.
Ms. Turnbull? You're muted.
That's my understanding as well. I think that Ms. Melton and Ms. West have done a very good job at helping this child transition.
Okay. All right. Ms. Melton, anything you wanted to add?
No, Your Honor, that sounds about right.
Okay. All right. So I want to thank everyone for the cooperation and working together to get this plan into place. Ultimately, the child needs to know and understand that. And so with that, I won't set any further reviews. Ms. Dow, do you need any further orders at this time?
I don't believe so, Your Honor. Let me just double check that the transition order dismisses Ms. Turnbull. I don't. Okay, all I see is that on that transition order is that the court visitor was discharged. So we may need an order discharging Ms. Turnbull.
Ms. Turnbull, if you want to go ahead and submit your final request for fees and then have it included in there that you're dismissed from the case.
I will do that.
Okay. And yeah, just submit them to court administration.
I'll do that. Thank
Okay.
you.
All right. All right. Thank you. That concludes this matter.
Thank you, Your Honor.
Thank you.
Thank you.
All right. All right. Who all do we have present?
Dee Dee Brill
And Jessica Starrett.
And Your Honor, I'm here, Sherry Farr, the guardian ad litem.
All right. So, at this point, Ms. Farr, where can you give me an idea where things are at?
Your Honor, I filed my report making my recommendation. We have an agreed order that was signed by everybody. I sent everything up to the court.
Let me just check. I was out yesterday, so it may have gotten scanned in. Let me. Okay, I see it.
And the order that I did send did not have mother's signature on it, but since she did sign after the fact, but I didn't send another one up. There wasn't enough time.
Okay. All right, just a second. Let me just go through this real quick. Anyone else want to be heard on this?
I can sign. I'm here at the courthouse right now. I have a hard time doing stuff on my phone, so I'm doing Zoom here at the courthouse.
Okay.
Your Honor, there were some blanks for you to fill in.
Okay, just a second here. All right, I do have the documents. I have, so first off, the orders and findings on petition to terminate or change minor guardianship. Let's go ahead and address that one. This is just signed off by the father.
No, we all signed it. We got a copy of the signed forms.
Okay, let me, sorry, I'm trying to make sure that I've got the right ones. I think that one was submitted earlier is why that's there. So this one I have signed off by Dad, Deanne Brill, and Ms. Farr. So for Mom, this is the findings, order and findings on petition to terminate or change minor guardianship or non-parent custody order. And on that one, are you okay to approve via Zoom?
I am.
Okay.
It says on my phone that I signed.
Here's a copy of it signed.
Yeah, it says on my phone that I signed it too. We can't even read that.
At least we see that you signed it though.
Right. Yeah, mine says the same thing.
Yeah, see.
Your Honor, would you like me to go through and
Hold on, just let me, I'm trying to, got a number of papers here, so I want to make sure that I'm signing the correct one. So this one I won't be signing.
So see, mine has a signature too.
Yeah, you can see yours too.
Okay. Well, the one I have does not. So as long as I have approved via Zoom, then that works for me.
Okay.
All right, so. All right, Ms. Farr, you said there was something that was needing filled in.
So section 1, we need to add mother's name as appearing. In section 7,
hold on, let me get that written in. Okay.
Section 7 needs some language relating to why the decision is being made.
So what I have added is there is a parent, comma, the father, comma, willing and capable of parenting the child. It is in the best interest of the child to terminate the minor guardianship. Is there anything else that you foresee needs to be added?
I believe that is perfect.
Okay.
Section 10 is for the transition time, which I don't know that if the parties have discussed when that transition is to take place.
Today.
Yeah, go ahead. Has it been discussed?
Yes, today.
Okay. Do you have a time?
He's actually with him right now. I'm at work. So it could be 8 this morning.
I'm actually going to put in no later than 10 p.m. because, or excuse me, 12 p.m. Just because that will be the time after this docket. So it doesn't
Okay,
make sense.
perfect.
And then, Your Honor, the last thing is that there is not a family law order or parenting plan in place at the time. At this time, Father said that he was going to be getting those documents ready to file this week as soon as this order was entered. So Mother has not had any legal visitation, and the parties have agreed that, except for the mother, that all visitation with the mother should be supervised. And so if we are able to put some language in there that gives some transitional time until the father gets the parenting plan in place. Mother previously had 191s entered against her, and
Right. So this is what I have put into place. Until the father has a parenting plan in place for the mother's visitation schedule, the mother shall have supervised visits with the child as determined appropriate by the father.
thank you.
So that means that I can like see Bradley with my mom and my dad.
So you'll need to work it out with the dad as to what that time, when it is, time it is, and who should supervise. Okay.
Okay. Thank you, Your Honor.
Okay. All right. Anything else, Ms. Farr?
I think that's it, Your Honor. Thank you. And I'll submit my fees separately.
So now Stan gets it, right?
I'm sorry.
So now Stan gets custody of him?
Correct. The child's placed with him until a parenting plan's put into place. So, Ms. Farr, I had a separate order.
Oh, I did send up a separate order for my fees. I'm
yeah.
sorry.
Are you okay if I go ahead and sign that today?
Yes, please.
Okay.
Got ahead of myself.
Okay. I've signed off on those orders.
May I ask when those will be available to pick up?
Usually it takes about 3 days.
Okay.
So probably Monday would be best.
Okay, great. Thank
Okay.
you.
Monday or Tuesday, probably Tuesday, honestly.
Okay.
Okay.
Thank you.
Thank you.
Yep, we're here.
Okay. Who do I have present on this matter?
Nika Kini.
And Rodolfo Munoz.
And Sherry Farr.
Okay. All right. So Ms. Farr, maybe you can have had a chance to look at it. I was wondering about service and.
Yes. So Mother has now been served. She was served in Oregon, so she was served on 8/8, so she gets 60 days. And Father is not able to be located. The petitioners did obtain an order to do a publication. When they went to go do that at the Daily News, they are charging almost $2,000 to publish for the 6 weeks. So my request is that service be waived on the father. The father hasn't had any participation in the child's life, and it's believed that the father may have returned to El Salvador.
Okay.
So it's very unlikely he would see the publication anyway.
Yeah. I don't know, and Ms. Farr, maybe you've seen this. I don't believe I can waive, but I've entered papers before where the parties were willing to take the risk of knowing as far as not having service on a parent. I've seen that.
Right. So in the statute, it says that the court visitor can recommend that it would be a hardship for service to take place, and the reasons why, which is why I just was explaining about he's likely in El Salvador, and then that is we just go forward without serving the father with that finding.
Okay. Do you have the statute number by chance?
I can look it up real quick.
Let's do this, Ms. Farr. Why don't do you anticipate the mom being involved?
It's probably very unlikely. The mother did sign a consent back in 2018, and she hasn't participated since. But I still think we need to give her the full 60 days, just.
Sure.
Yeah.
No, my thought was, so you don't have to spend time trying to find that statute right now, is go ahead. When do you anticipate a report to be done?
So I wasn't sure what was going to happen, if we were going to set this out 60 days. If we're going to set it out, well, wouldn't it be more like 6 weeks at this point? Then I could have my report done prior to that. And then we can just, or if you want to have a review hearing prior to that to make a finding on the service on the dad, like in 30 days.
So why don't I go ahead and do that? And meanwhile, you can look for that, so you don't have to look for it at the moment, and I'll try to see if I can find it too.
And I'll include it in my report.
Okay. So we're on 22nd September. How about we set it to September 26th?
That would be great.
Okay. And I should ask, anything else that you want to say today? Are you understanding what's going on?
Oh, for us, sorry.
Right.
No, I don't think we have any questions. I don't have any questions.
So we're going to have another hearing on the 26th next month.
Correct. And that will be at 10 a.m. 10 a.m.
And that will be going over.
And that will be one. So Ms. Barr is going to look up that statute so I can waive service on dad. I wondered what was going to happen because I knew he had probably gone back to El Salvador. And so
on the 26th, the docket's at 10 a.m.
Right. That's what I just told him. Yeah.
Are you signing another order to extend?
Yeah. So I'll sign an order extending, and then, so, basically the order will continue. I was thinking, did I need it to on this one?
I'm just looking at the last order and it looks like.
The emergency order does expire today.
Okay, I'll extend it, but I want to extend that order out for the 60. I thought I had already done that, but I think I may have just put in the, let's see, so 6 and I'm just going to go ahead and extend it because I think that'll probably be, let's see, service was
8/8. So the 60 would be up, the October 10th would be that Thursday.
all right. So I'll extend it to October 10th. Okay. And then on the 26th, we'll talk about the waiver. And that should pretty much do it.
Thank you, Your Honor.
Okay.
Thank you.
All right. Thank you.
Thank you.
Good morning, Your Honor. This is the guardian ad litem, Amy Turnbush.
Okay. Who else do we have? We have
April Nicholas.
Guardian April Nicholas. Anybody else that we have on today?
Angel.
Okay. Thank you. Anyone else? All right, Ms. Turnbull, can you update me from where you're at with this?
Yeah, we are still trying to serve both mother and father. Mother, I think, has been avoiding service and has moved out of her apartment, and April has not been able to locate her. Family members aren't willing to tell her where she is, other than she's somewhere safe. Father, we've determined he's probably in the Portland area. He's a registered sex offender. We found him on the sex offender list, but the address that he is registered to is apparently not a valid address, and the police and service have not been able to locate him there. So I'm wondering if we need to look at potentially other means of service for him and maybe for mother too. I don't know if April wants to weigh in on that, but She's not having any luck there. She's been on vacation. I believe she does have the paperwork for the full guardianship petition in hand.
Okay.
And hopefully we'll have that filed shortly here.
Okay. All
I
right.
have tomorrow off, so I'm going to be bringing the paperwork in tomorrow morning to the courts.
Okay, good. Okay. All right. And so one of the questions, Ms. Turnbull, is because of the age of Angel, have you talked to her about whether she wanted an attorney or not?
Did, and I'm trying to remember, but I believe she did. Is that correct, April? Yes.
You and Angel spoke for a long time, and I wasn't able to
You weren't
hear
there.
the whole conversation
Yes,
because I really want to give
she
her
did.
respect.
She does want an attorney.
So sorry.
She does. She wants an attorney. She would like to attend the hearings. She would like to review the paperwork, and she is in agreement with the guardianship.
Okay. So we'll go ahead and get an attorney for Angel. And then, so if you're still looking at service, and what's going on there, what are you thinking as far as your report?
Well, other than not being able to contact myself, mom or dad, I have everything else, and not having service, I have everything else ready to go to write my report. So if you'd like me to complete it as is, I'm ready to do that.
Okay. All right. Well, let's see about the service. And so I think what I'll do is go ahead, because we need to get an attorney on board for Angel, is go ahead and set this over. Let's see, we're on the 22nd, 1, 2. So September 5. Let's set it to September 5 to see that we have an attorney for Angel. And then meanwhile, I'll go ahead and extend the emergency let's see, looking, since we don't have.
Your Honor,
Yeah.
sorry. Angel has a doctor's appointment on the 5th at 10 o'clock.
Okay. So let's go ahead and set that over to the 12th then. And then I will go ahead and extend the emergency matter out to 10 July. I'll just go ahead and extend it to September 26th. Okay. So I think that's all we need to do today. Get the attorney on board for Angel, extend the emergency order, continue to see about the service, see if that's what you're going to be doing, and then we'll go from there.
Do you want me to wait to file my report, or go ahead and file it with the information I have?
Go ahead and file it with what you have, and then I'm not necessarily thinking that we're going to get service on the parents from what especially if they're avoiding service. And then you can always, update or amend.
Okay.
Okay.
Sounds great. Thank you.
All right. Thank you.
All right. Thank you.
Got a couple of things going on here. All right. Ms. Winkles, are you there?
Yes, Your Honor. I think for today, we could just extend and get a visitor because we can't find him. We've tried Facebook, we've tried email, we've tried everything.
Okay. Okay.
I think I was appointed on this one too.
Oh.
I don't see that you were, Ms. Turnbull, but maybe you were.
It's at the very bottom of the order on emergency minor guardianship, number 18. I've never seen it like this, but I was forwarded this and the perk.
Oh, that I just put both names of the person that might be appointed, and I thought we could scratch one out. I'm not sure why the clerk forwarded it to you.
Somebody scratched one out.
Oh, well, I guess maybe they already looked at who was available.
And I said, I've never seen an order appointing a guardian like that. She said, I haven't either, but she said I was appointed. So I'm happy if something needs to change. That's fine with me. But
And I have no issues with that. I'm a bit surprised myself because it was just a proposed order, but if she's already on board, we just need to find dad, so that's great. And
Well,
dad may be dead.
Are you talking about the order appointing emergency minor guardian?
Yeah, and number 18.
Okay, under the order appointing, that was actually lined out, blacked out.
The whole thing was, that's fine. The clerk emailed me and said I'd been appointed, and I said, I don't see an order appointing. She said, it's under, it's at the end. I said, I've never seen anything like that. She said, me either. So I think it was just maybe a misunderstanding.
Yeah,
so I'll let you carry on.
We're training law clerks, so it's kind of a process.
All right. So I do believe, now that I've said that, I believe that you're next on the list. So it's going to be you.
Appointed, will it? Because I think you just appointed.
That's true. You were just appointed in the Meisner matter. Let me go check real quick and I'll find out.
Okay.
We're training law clerks, so it's they're baby lawyers in training, and sometimes I miss things when I'm reviewing.
Well, that's no problem. It was actually from the clerk at the courthouse that.
Oh, well, it might be as well because the statute might allow that, and they're very big into reading the law and doing it exactly. So maybe there's something in the statute that allows for a court visitor to be appointed on the ex parte order. It makes sense.
No idea.
It makes sense.
I have no idea. Pardon me.
All right. So, Ms. Turnbull, no, it would not be you. You're correct. You were marked off with that last case, Meisner.
Okay.
So it would be Sherry Farr.
Okay. Thank you.
Thanks, Amy.
You're welcome.
All right. So we'll go ahead and appoint Ms. Farr, court visitor.
And I'll get those orders to everybody and extend the emergency till our next hearing if we want to set the next hearing, or I can docket it, whatever's easiest.
Okay. Nothing else that you need today?
Nope, just to have that in place. That's great.
So Ms. Winkles, it looks like I will need an actual independent order.
Yeah, and I'll get you that.
Okay, perfect.
All right, so we'll go ahead and you want to set it out a month?
Yeah, let's set it out a month because I have a sneaking suspicion dad is deceased.
Okay, how about September 26th? Does that work?
That works for me.
Okay, at 10 a.m.
Yep, will do.
All right.
And I'll get those documents to everybody.
All right, that's it.
Thank you, Your Honor.
Thank you. That concludes the docket.